Hi, I'm Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City. And in this video, we'll be discussing a very common question that comes up for those applying for an E-2 investor or an E-2 employee visa and whose spouse or dependent children will be joining them. Specifically, do E-2 dependents receive authorization to work and study? There have been some very positive developments in this area in the year 2022, and I'm looking forward to sharing those with you in this video. Before we dive in, if you're interested in more information about the E-2 visa requirements, we've posted to our YouTube channel our full webinar on the E-2 visa. We also share a lot of free information about the E-2 visa and other visas on our blog. We'll link to both our blog and our YouTube channel below, so do check those out. So, you've applied for or have received an E-2 investor or E-2 employee visa, and you have a spouse, you have children, or you have both. In this video, we'll call the E-2 investor or E-2 employee the E-2 principal. And we'll call the E-2 principal spouse and any unmarried children of the E-2 principal who are under 21 years old the E-2 dependents. You may already know that the E-2 dependents are generally eligible for E-2 dependent visas, which allow the dependents to either come to the United States with the E-2 principal or to join the E-2 principal at a later date. The benefits that come with an E-2 dependent visa are different, depending on whether the dependent is the spouse or a child of the E-2 principal. The E-2 dependent spouse can work or study in the U.S. The E-2 dependent children can study, but they can't work in the U.S. By being able to study, either the spouse or the child can take classes or enroll in a degree program at a school. Now, before 2022, there was a good amount of confusion and debate as to whether the E-2 dependent spouse could start working as soon as they arrived in the United States, or if they needed to apply for and receive a separate work permit, also called an employment authorization document or an EAD, before they started work. There was case law and even disagreement within the government itself as to whether the E-2 dependent spouse actually needed a separate work permit, but the safe and conservative advice was that the spouse should not start working until they had arrived in the United States, applied for a work permit by filing a Form I-765 with USCIS, and actually received the work permit. This arrangement, though, became particularly problematic when USCIS began taking months and then over a year to adjudicate work permit applications. This put E-2 spouses and their families in a difficult place since they had done everything they were asked to do by the government, but then they couldn't work for months on end due solely to the government's inability to operate efficiently. In November of 2021, this situation fortunately started to change for the better. On November 12, 2021, USCIS announced in a policy alert that E-2 dependent spouses are authorized to work pursuant to their status, and therefore they no longer need a separate work permit. The government actually implemented this change starting on January 30th, 2022. So how does an E-2 dependent spouse know whether they have authorization to work pursuant to their E-2 dependent visa status? They'd need to take a look at their Form I-94, which is issued by U.S. Customs and Border Protection, or CBP, upon their entry to the United States and should designate their status as E-2S, S as in spouse, in order to distinguish them from E-2 dependent children. E-2 dependent children's I-94s show E-2Y. That's right, the delays in work authorization that so many people experienced came down to the government's willingness to distinguish spouses from their children on the Form I-94. If you're an E-2 dependent spouse and your I-94 is designated E-2S, you can begin working upon your arrival in the United States and do not need to apply for separate work authorization through USCIS. U.S. Customs and Border Protection makes it easy to check your I-94 online. We'll include the link to their website below. For those E-2 dependent spouses who change status from within the United States, starting on January 30th, 2022, USCIS also began issuing on the I-797 approval notices I-94 forms with the new E-2S designation. With this, the E-2 dependent spouse is eligible to begin working in the United States and does not need a separate work permit. An unexpired Form I-94 with the E-2S designation is acceptable evidence of employment authorization for E-2 dependent spouses on the Form I-9. And along with a valid identity document, those documents will complete the I-9 process, which is required for them to work. Note that those E-2 dependent spouses who either already have a valid employment authorization document or who apply for and receive one will be able to use the EAD to show both their identity and employment eligibility. What if an E-2 dependent spouse checks their Form I-94 and it doesn't have the E-2S designation? The steps they would need to take depend on when their most recent I-94 was issued and whether it was issued at a port of entry by U.S. Customs and Border Protection or from within the U.S. by U.S. Citizenship and Immigration Services after the spouse filed an I-539 application to extend or change their status to E-2 status. If the spouse received their most recent Form I-94 at a port of entry from CBP after January 30th, 2022, and their I-94 does not show the E-2S designation, they should contact a CBP deferred inspection site nearest to their port of entry. Since CBP should have started issuing I-94s with the E-2S designation before the date of entry, the spouse should inform the deferred inspection site that there is an error on their I-94 and request that the deferred inspection site correct it. We'll include a link to CBP's deferred inspection sites below. If the spouse received their most recent Form I-94 at a port of entry from CBP before January 30th, 2022, there's a good chance that their designated status is E-2 rather than E-2S. They can still attempt to have a CBP deferred inspection site correct the I-94 to include the E-2S designation. However, since CBP only implemented the new designation on January 30th, CBP may argue that this is actually not an error and therefore cannot be corrected by CBP. This would mean that the E-2 dependent spouse would either need to leave and re-enter the U.S. on their valid E-2 visa in order to receive a new I-94 with the E-2S designation, or they can apply for an extension of status through USCIS, which, if it's approved, would result in the spouse receiving a new I-94 with the E-2S designation. Since there's no option for an E-2 dependent to apply through USCIS with premium processing, it could take months for USCIS to adjudicate the application. The situation is a bit different if the spouse received their most recent Form I-94 through USCIS. Starting on April 1st, 2022, USCIS began mailing notices to E-2 dependent spouses who held valid I-94 forms issued by USCIS before January 30th, 2022, and that therefore did not have the E-2S designation. The notice and valid Form I-94 together served as sufficient evidence of employment authorization, meaning that the E-2 dependent spouse did not also need a separate work permit. USCIS announced that those E-2 dependent spouses who do not receive a notice by April 30th, 2022 should email USCIS to request the notice. We'll include this email address below. Note that the USCIS notices were not issued to those who received their most recent I-94 from CBP. Those spouses would need to follow the guidance discussed earlier in this video. We hope this video about work authorization for E-2 dependent spouses was helpful. If it was, please click the like and subscribe buttons below to stay updated on future videos about visa options and travel to the US. Thank you for watching.